All right, ladies and gentlemen, welcome back to another episode of the Spunky Pro podcast. Today we are starting a new series, which is not going to run every single week. In fact, it's going to be running once a month probably, just because of, well, honestly, the length of this series that I want to do, but then also maybe it can get a little dry. But the series is called the ABCs of Rental Laws. And basically what I've done is I've compiled a list of topics that we should be familiar with as rental investors in our state statutes. So these are going to be like items from security deposit deadline to abatement of rent policy to tenantability, and we're gonna basically have a conversation about all of these things that you should be looking into to be sure you understand the law, because we want to be sure we understand the law so that we, number one, we stay in compliance. Number two, when we go in front of judges, which I would honestly say God forbid you do, but if you've been here long enough, I just basically say you should plan on seeing a judge at some point in your real estate investing career. It's going to happen. Sorry, mostly everyone does at some point. Anyway, when you appear in front of a judge, the more knowledge you have on state statutes, presented politely, by the way, we're not coming across as a know-it-all jackass, but presented nicely, you have a higher chance of winning and receiving a favorable judgment from the judge, but then also just keeps you out of trouble. Like, let's just go with that one. It just keeps you out of trouble. So we're going to start this series. It's going to be the ABCs of state rental laws that you need to know. We're going to be going through them in alphabetical order, one podcast episode a month, because I don't want to overwhelm you guys. Like, all this is going to involve some research on your end in between episodes, because I don't know what state you're in. You're in New Mexico, you're in Montana, you're in New York. All of your answers to these topics are going to be different. So I want to be sure and give you enough information to be able to make the research that you need to do, but then also kind of not be completely lost in this conversation. So here we go. You guys also know that I don't write scripts, so we're on the fly here. All right, so obviously we're going to start from the beginning of the alphabet. We're not going to start with Z. I thought about going backwards, but I'm like, no, nobody else is going to appreciate that except for me. I'm the person that doesn't wear matching socks, so of course I would totally opt to start with the end of the alphabet, but we're going to start with the beginning of the alphabet. Okay, so first we actually do have abatement of rent. So if you don't know, abatement of rent is the situation where your tenant may or may not have the right to withhold rent based on repairs or condition of the property. Now, this doesn't mean necessarily that they never have to pay you. That all gets back into your state statutes. For instance, in Wisconsin here, it doesn't mean they don't have to pay it. They have to pay it. It will become due once the situation is remedied, and it's payable like basically immediately. Now that's Wisconsin. But you need to be familiar with your state statute so that when it comes up, you don't feel like, well, I don't even know what it is. I don't know what Montana says about it. So take a few moments to actually Google abatement of rent regulations or laws, fill in your state, and figure out what all the guidelines are. I'm recording this podcast while possibly starting to come down with something. And so I'm like, if I don't record it now, how long am I going to be sick for? And it's like, I haven't recorded for you guys in about 3 weeks. So I'm like, I've got to record. So my voice is going to crack and whatnot through this. I apologize. You'll even see me drinking through this. Just want to get one out there for you guys before, I don't know what happens to my voice when I get sick. We'll see. So you just want to be sure that you know about abatement of rent before it comes up, because this is definitely one of those situations. It's going to be a high stress situation for you to be like, oh my gosh, my tenant is refusing to pay me rent. They're talking about this word abatement. I don't know what it means. I don't know what my state statutes say. Think about how much easier it would be for you if you already had this information at your fingertips. So take a few minutes, research abatement of rent in your state, and see what your state regulations are. All right, next on our list of ABCs, we're getting into application fees. So application fees, that is a fee that you can charge to a prospective tenant for running their application. Some states allow you to charge up to a certain dollar amount. Some states say that you can charge up to your exact fee. So your state statutes might be written, for example, and I don't know if this is true, South Dakota, it might say that you can charge your exact amount. Obviously, it will be written that much in plain language because it's state statutes. They got to make it more confusing than just, plain bar language. But anyway, your state statutes might say your exact cost with no limit. Here in Wisconsin, it's exact cost, but up to $25. So if our exact cost is less than that, we have to charge that exact cost. So if your cost is like $18.99, it's kind of a pain in the butt, but you have to charge like $18.99 here in Wisconsin. You technically shouldn't even be rounding it up to $19 because that's not your actual cost. Like if we're going truly into the letter of the law, but then one could certainly argue the spirit of the law says $19 would probably be fine. But that's something you want to find out in your state statutes is what is the application fee rules? Is there a limit on how much can you charge? You're required to only collect the amount that it costs you? And by the way, in a lot of state statutes, the wording for actual cost is usually interpreted as in you paid somebody else for this service and you paid them $18.99 to get that. So even though you could say in your head, you might make the argument, well, I spent 15 minutes of my time running the application. My time is worth $30 an hour. So tack on, I don't know, rough number, $10. My application fee is $28. That might not actually work if your state statutes have the language of exact cost. So just be aware of that when you're looking through your state statutes of the wording of exact cost or not, because that means it really is just whatever you pay somebody else to do this. So if you are someone, and I don't recommend this, you guys know this, I say always do credit checks, but I know there's people out there that only do criminal. I can't save everybody. I can just save those of you that actually listen to me. So if you are able to get criminal records free in your state and that's all you use, then you can't actually charge an application fee if your state says exact cost. Okay, so that covers application fee. The next one we're going to talk about is credit report. So in your state statutes, there probably is going to be some language regarding your credit reports and background checks. So on top of talking about like the application fee, there might also be something in there that says that a landlord must accept a credit report that is less than X days old. So if Jane went and applied to an apartment over on Hartford Court and then she saw something over on Quail Court and then yours, and Quail Court ran her application and gave her a copy of her credit report, she sees you a week later. If she can give that to you, you actually might have to accept that credit report. In Wisconsin, that is true. So if she came to me with her credit report from Quail Court, I would have to accept that. We could go on a totally different tangent about processing applications and everything with that as far as like how it affects the credit check if it's all bundled into one service for you, but I feel like that's a really big tangent that we don't need to go on. So we're just going to stick with this idea that you want to check your state statutes to see if there is a requirement for accepting a credit report a tenant presents to you, a prospective tenant presents to you, that is younger than X days or not older than X days. Here in Wisconsin, it's 30 days. It could be 15. It could be maybe 45. I don't know if I see it honestly being much longer than 30 days. But that's something you want to check out in your state statutes. Then the other thing you want to check out is just making sure that you are in compliance as far as storing the credit reports, because credit reports are a confidential item, which means that likely you checked some box somewhere on a form, or every time you go to run a credit report, it says you are liable for all this gobbledygook that is like 3 paragraphs long and 0.12 size font, and you're like, yeah, whatever. Likely in there is somewhere where it says that you are going to store the data in compliance with your state statutes. So make sure that you are actually storing your data in compliance with state statutes, and that includes digitally as well as like physical copy. So you can't see it, but if you have an old filing cabinet like I have back there, which I don't even know really what has in there anymore, but that probably might have to be a lock and key cabinet per your state statutes. There might be regulations regarding data, like storing it on a cloud. So if you're storing it on a cloud, your state statutes might say that you have to make sure the password to where it's stored is changed X number of months. I don't know. I'm literally just making shit up at this point, but I'm just trying to get across the idea that there could be certain regulations regarding how you store your credit report information after you receive it. There's also going to be credit report requirements as far as giving the tenant a copy. So I just talked about how at Quail Court, this lady could have had her credit run and bring it to me. That's because in the state of Wisconsin, you do have to provide a copy of the person's credit report if you run it. So that's another thing you want to be sure that you are following within your own state statutes, that you are giving people copies of their credit reports if it's required by your statutes. All right, the next thing on the list I have, and I don't necessarily pretend this is an exhaustive list, but my goal was to get to the D's on this podcast, and so we're going to talk about damages. So damages is a pretty hefty one, to be honest, and this will take us, honestly, the rest of this podcast episode. So in your state statutes, you're going to want to look for anything that is about damages in regards to mitigation of losses. So mitigation of losses falls under damages because it's part of the security deposit process. So when you have a tenant that moves out, either you evict them, they willfully give it back to you, or you give them a non-renewal. Anything that's sort of taken out of the security deposit in general lingo is usually called damages. And that includes like back rent, late fees, but then also it can include, as we're talking about here, mitigation. So it's the mitigation of your losses. This comes into play when a tenant breaks their lease. So if they are on a 6-month lease with you and they decide, you know what, after 4 months, this doesn't work for me anymore. The neighbor upstairs that moved in 2 months ago was really annoying, or I just need to move away from this neighborhood. I don't like it anymore. It's too dangerous in their mind. Whatever it may be, they are choosing to fly the coop and basically break their lease with you. You have a loss for the duration of that lease, and that is where you need loss mitigation. So the loss mitigation you're going to research for is just making sure that in your state statutes, you are entitled to regain that loss through mitigation. Now, mitigation is not necessarily a legal process, but it's more just allowing you to recover the security deposit for that unpaid rent that you were entitled to because they entered a duration of a lease. This is all the stuff you've got to kind of, this gets a little, I know, a little tricky here. This one gets a little tricky. It's not quite as easy as the other ones we were talking about, because you're probably going to have to read a couple lines of state statutes to kind of figure out where this stands. But you're going to want to look and see what kind of restrictions there are on mitigation. So if the tenant, is able to prove XYZ to you, maybe you aren't able to mitigate your losses against the lost rent. But it's something, again, that you want to be aware of. Another thing regarding damages is what are your measures of recovery? So measures of recovery are what you can actually do to make yourself whole again for any of those damages that you might have incurred during the course of the tenancy. So again, the damages could be, lost rent. It could be physical damage to the property. It could be unpaid fines or fees. It could obviously be unpaid utilities, things like that they were responsible for, but they didn't pay it. These are all examples of your damages, and so you got to be sure you know your measures of recovery. And basically what that means is your measures of recovery is the steps that the landlord would have taken to rent the premises if it had been vacated in due course earlier than the lease expired. So you are bound to trying to re-rent the unit probably in some fashion, in a timely fashion, albeit, so that you can try and recover some of those losses that otherwise would fall on the tenant. So your measure of recovery statute is likely going to say that you have to make every effort to turn over the unit in a timely fashion. You need to be able to prove that you're fixing it up in a timely fashion and that you tried to actually rent it. That you didn't just like sit on it for 6 months for the remainder of the year lease and be like, yeah, no, see, now you owe me that money. State statutes want to protect the tenants and make sure that landlords aren't just sitting on a vacant property and saying, well, I'll just collect it from this tenant's security deposit, which they have with me, which is 2 months or 3 months rent. Obviously not everyone has a standard security deposit, so you could be in a situation where a tenant's breaking a lease and technically their security deposit covers the remainder of the lease, 2-3 months. You still got to make every effort and get that unit out on the market as soon as possible so that you are attempting to recover some of your own losses before you kind of push it over to the tenant with a final statement in front of the court as far as damages. I know it's a little thick, guys. It's a little thick in the weeds here, but just follow me here. Then with damages, there's likely going to be some requirement as far as the itemizations of it. So how do you have to itemize your damage? And then the big one here, let's talk about this. Let's just get the big one done with. Damages. What are damages? Now, we talked about the rent and everything, but physical damages. Maybe not necessarily in your state statutes. Some state statutes are super good at this, and I love it, where they actually specify what constitutes physical damages. But you might also have to do a little bit of extra research outside of the state statutes where maybe you're looking at a court case that's ended up at your state Supreme Court, and that might actually give you a definition of what physical damages are. I'm going to use some stuff here in Wisconsin just to give you an idea of what I mean by what will be defined as physical damages or not. So if I have a vacant unit that's been turned back over to me and I'm strictly looking at it from the physical damages perspective of it, if there's a fist-size hole in a wall, that's going to qualify as physical damages here in Wisconsin, and I get to charge for it. But if we're in the kitchen and let's say there are maybe 2 cabinets out of 15 that have a little bit of a sticky residue on a couple of the shelves, am I able to charge for that? Well, it's not in Wisconsin state statutes, but there's a Wisconsin State Supreme Court case that points to you can charge if it adds substantial time to a task that would normally be completed for turnover anyway. So normally we are expected to basically do a light cleaning of every unit here in Wisconsin before we turn it over. If that light cleaning goes from being a 15-minute wipeout of the cabinets to a 45-minute wipeout of the cabinets, that certainly added a fair amount of time to the task, which means I could charge for it. Now, those shelves that I talked about in 2 cabinets, 2 shelves, 2 cabinets, it's probably going to add like maybe 5 or 7 minutes probably to my cleaning, which means that under state statutes, I would not be entitled to charge for that, because that goes beyond this idea of 5-7 minutes is not really a large amount of time in the grand scheme of it. So another example of this would be if you have, I like cleaning as a good example of this. So perhaps you have an oven that you could wipe down, just wipe out quickly. There's just a little bit of like self-cleaning debris in there, but not a whole heck of a lot. Here in Wisconsin, that's not something you could charge for. Let's say they didn't use a self-cleaning cycle at all, or they did, but they never cleaned their oven for like the 2 years they lived there before using the self-cleaning cycle, then yes, I could go ahead and charge for that here in Wisconsin. So you're gonna wanna see if you can find some sort of indication of the physical damages threshold. So they might have something that says if it adds substantial time, or if it increases the time by half, or it may even be just a requirement of like there has to be some sort of physical visible damage that requires additional effort beyond the normal capacity of work. There's many different ways this could be worded in your state statutes, but it is really important for you to understand what does constitute physical damages and what is sort of just considered, we in Wisconsin would call it normal wear and tear, that you're expected to absorb as part of the process, because that is a thing. I mean, at least here in Wisconsin, it's a thing. There's this normal wear and tear. So wiping out a cabinet, all the cabinets before move-in, that's kind of expected to be normal wear and tear that I'm expected to do. Unless, of course, my time is increased substantially, I cannot charge for that. Okay, then also look in regards to any regulations as far as damages that the tenant causes while they're still there and in relation to tenantability. So if a tenant causes damage to a property that is basically, let's say, on facial damage. So it's stuff that doesn't really affect the mechanical works of the building, but it kind of affects the aesthetics of the building or their unit. So they got a few hole punches in the walls. Maybe they really scratched up the front door trying to get in a new sofa or something. I don't know if a sofa would really scratch a front door, but they were bringing in a brand new entertainment center and it scratched up the front door. Look at your state statutes and see for a couple things. Like, number one, what kind of documentation might be required of you for this damage so that you can charge for it when they move out. Number two, do you have any requirements as far as fixing it if it is requested, even if it is damaged by the tenant? Depending on the state you live in, not wanting to get political, but you guys know by now, states that are liberal tend to be more open towards tenants versus ones that are conservative tend to be more open towards the landlords. And then usually we can find states that are pretty good balances. Now, in the event that you're in a more liberal side of the state, I think it's a perfectly reasonable expectation that you might have something written in your state statutes that you have to fix tenant damage even if they haven't paid for it, if the tenant requests it. So you'll want to take a look at what your requirements are for fixing tenant damage that does not affect the usability as well as the functionality of the unit. Obviously, if they cause some sort of damage that prevents them from using the toilet and it's their only toilet, you're likely going to have to address the toilet damage. The same thing goes for, let's say, something in the kitchen. So let's say they damaged their oven and it can't be used anymore. You're likely expected to do something with that without really having the tenant pay for it. And that kind of goes for most states, honestly, because now that doesn't mean you can't charge them for it, but it's like you can't hold up the process just because they haven't paid you for it. Because regardless of what your state statutes say about like damages and tenants paying for them ahead of time if they caused it, it's likely not going to cover things that are fixtures or things that affect the functionality of the unit. So just keep that in mind as you're looking through them. So we talked briefly about burden of proof just for a moment there. So we want to be sure that we have a burden of proof that the damage was caused by the tenant and how it could have been caused by the tenant. But then also, once we fixed it, you'll likely want to have proof that you fixed it if you have the feeling this is going to become a recurring issue. Because somebody could easily make the same hole in the wall by the closet door and they could be like, well, yeah, but they never came to fix it before, so I shouldn't have to pay for it now, sort of thing. So it usually is a good idea to keep up with your burden of proof and always make sure that as far as damages go, you know what the burden of proof is in your state. Okay. All right, we're almost done with damages, which is good because I know this is one of the least desirable topics in our A to Z. And I kind of felt bad I was going to come into our first episode, but I'm like, you know what? I got to do it. Okay, so damages, you're also likely going to find some sort of section that talks about the damages that you need to inform the tenant of prior to moving in. So in some states, this is put under damages. We'll talk later on about another section this might be put into. But in some states, you might have a requirement to disclose prior damages to the unit. So if the previous tenant took a baseball bat to the overhead garage door and completely ruined it, you might be under an obligation to disclose that. Again, this isn't going to be a lot of states. I can tell you here in Wisconsin, we don't have a disclosure requirement for that sort of damage. We do have disclosure requirements for untenability or unusable utilities, but we don't have anything as far as previous damages. You likely can be asked by a tenant for a list of the previous tenant's security deposit damages. That is something that is protected here in Wisconsin. So once a tenant gives us notice that they want to see the previous tenant's security deposit deductions, we have a requirement to do it in a timely fashion. So that likely could be something that is covered somewhere in your state statutes for damages as well. So know what your requirement is for disclosure of prior damages to the unit. Then it's also just going to basically give you a basic definition of damage. Like, beyond physical damage, we talked about all these other things. They're going to have their own little definition of damage and what they consider damage. So be sure you know what your state actually says damage is in regards to a lease. Not just the rental unit, but the lease, damages for a lease. So damages for a lease would be uncollected rent for breaking a lease. It could be, like we talked about before, the sewer that remains unpaid. So you want to be sure and know every single definition for damages and what that kind of encompasses in your state statutes. Whew. All right, so that gets us started with the D's. So in our next episode of this, which will happen about a month from now, we'll go through disclosure requirements. And this is going to be a pretty hefty one. There's a decent chance this might possibly be half an episode in itself, maybe, possibly. And we're going to talk about domestic abuse protections. And then we're going to possibly get into earnest money. I probably would say we're going to get into domestic abuse protections and we're going to get into disclosure building requirements for leases, and that's where episode 2 of our ABCs of Rental Law series is going to land us. All right, guys, I hope you got something from this episode. I hope you've been taking notes about the things that you need to quickly research for your state. So I said in the beginning, and I'll say it here again, just so you have it. When we talk about Googling these things, the easiest way to do it is just put in your state. So I haven't mentioned Iowa yet in this podcast. So we'll say Iowa rental physical damage regulations. And then basically it'll bring up everything that it feels is pertinent within state statutes for Iowa regarding physical damage. One thing I do not recommend, guys, is just going over to your AI and asking like Gemini or Grok or ChatGPT, hey, what is the physical damages requirement for Minnesota? You probably heard this dozens of times, but if I don't say it, you might be like, well, I don't know, why should I do that? It's because AI sometimes makes shit up. It does. I caught it today, making shit up for me. Like, I know that's not true because I looked for it and I couldn't find it, and there's no reason that this really should exist if I couldn't find it. So, you were lying to me. Stop it. So that's why I don't want you guys necessarily just going over ChatGPT and saying, tell me the disclosure requirements for building codes for rentals in Tennessee. AI makes mistakes, guys. It makes stuff up. It makes mistakes. It misinterprets things in its algorithm. Just don't do it. Just don't do it. Take the effort yourselves. Put in a little bit of time. Now, it's perfectly fine if you find something, let's say in your Tennessee state statutes, and you're like, yo, what does that mean? I cannot even begin to comprehend all of those legalese languages, words that are in there. It's perfectly cool to copy and paste that over to ChatGPT or Gemini and ask it to translate it into, I like to use a 12th grade vocabulary. So that's a really cool tip for you guys. I've got much, much more in the future. I'm going to be actually hosting a course on AI and real estate and how to use it and how to write some good prompts. But there you go. There's your first little tip for the year. If you ever want ChatGPT or anything to translate something for you, not necessarily from a different language, but from like legalese or like maybe very specific construction language, in your prompt include translate this into blank grade, 12th grade, 8th grade, whatever you feel like you want. I probably wouldn't go below 8th grade because I feel like that's just going to get even more difficult to understand because it's going to try and dumb it down too much, which is definitely a thing. You can dumb something down too much. So translate this to 12th grade language for me so I can understand what this is trying to tell me, and then paste the statute language in there. It's going to give you a really good feedback of what exactly that says because you're feeding it the information. You're telling it, hey, translate this specific thing for me. Chances are it's not really going to be making up anything as far as what's in there because everything is there. It's just translating it for you into, well, a dumbed down language. I mean, that's really what we are. We're taking legalese to street ease, 12th grade street ease, so that we can understand it. All right, guys, thank you so much for listening to this episode. Thank you so much for watching. If you watch this on YouTube, YouTube is brand new for me. I just got myself a nice little external camera. Didn't have one prior to this. I thought the onboard one would be well enough. Yeah, that was stupid. So I got a nice new external camera. I've cleaned up my studio permanently for this. Yes, there's still some randomness. Like here, if I turn myself this way, you can see there's still like a portion of a bed here in my studio. I don't know where that's going to live. It's something I'm choosing to keep because it's an heirloom from my family. It's been in our family for like 70 years, just not currently using it, but it lives in here right now. But yeah, so this is my studio, guys. This is where I record stuff for you, podcasts, reels a lot of the time. And this is where, I mean, when I'm not remote working, this is where I do a fair amount of my work. All right, guys, that being said, I wish you guys a wonderful week. I hope you are staying warm if it is cold wherever you are. When I'm recording this, half of the United States is in the rather frigid temperatures. The other half is, well, getting shitted on by Mother Nature with a lot of storms and snow, even in Texas. So I hope you're all safe and happy and that your rental units, your flips, and everything are surviving this god-awful winter that basically most of us are having to deal with right now. See you guys next time.